Hello viewers, welcome to my YouTube channel. My name is BIANCA-LET'S. Today we are looking into a settlement agreement and the effect it has on both parties. Then I'm going to make also a comparison between the South African setup and the Namibian setup in this regard, because they are different. You understand the difference. So a settlement agreement, first and foremost, parties need to ensure that they stipulate the terms of the settlement clearly in that the names are correct. If there's an amount to be paid, correct amount to be paid, the terms attached to that amount to be paid, the conditions, everything clearly stipulated. Once that is done, both parties need to sign. Once that is signed, both parties are bound to that settlement agreement. Now, I'll go stage by stage. So if this settlement agreement has been entered into before a case is referred to the Office of the Labour Commissioner, and it's now in existence, there's a settlement agreement in existence which binds both parties, and one party decide, no, I'm going to disregard it, I'm going to the Office of the Labour Commissioner. The other party can raise it as a preliminary issue and say, no, we entered into a full and final settlement agreement. Here it is. The signatures are here, the names are here, and therefore this dispute is not proper before the Office of the Labour Commissioner. Guess what's going to happen? The arbitrator at the Office of the Labour Commissioner will immediately have the case thrown away, under the name or umbrella that a dispute was resolved. So there's no dispute to be had, because there is a full and final settlement agreement entered into by the parties. So then, case closed. Now, let's go to the next one. Now, in this situation, a dispute is referred to the Office of the Labour Commission. There's no settlement yet. Either you are to appear at conciliation or you are expected to continue with arbitration. At whatever stage before the award is given, parties decide, let's enter into a settlement agreement. That settlement agreement again stipulates the terms properly. Correct names, conditions attached to that settlement. If it's parties that are preparing it, prepare it, give it to the arbitrator. Then the arbitrator will make an award by agreement from that. And then either party can take it to the Labour Court, have it endorsed, put the case number there, and then in a situation or a circumstance whereby any of the parties or one party failed to honor part of that agreement, the other party that is affected can approach the labor inspectors or the deputy sheriff. My apologies, the deputy sheriff, for it to be enforced. And if it is before the arbitrator can also draft it himself or herself, indicate award by agreement there on top, gives it to both parties. Either party can decide to take it again to the Labour Court, have it endorsed, and then present it to the labor inspectors or deputy sheriff at a time of default for it to be enforced. Now, here is the interesting part. You hear all this process, how it's done in Namibia. In South Africa, the first step, let's go 10 times backwards where we came from. In South Africa, if you enter into a settlement agreement, right? You enter into a settlement agreement before a dispute is referred to the Office of the Labour Commissioner. The law in South Africa, I think in terms of section 189, if I'm not mistaken, speaking under correction, you can still take that settlement agreement to the CCMA and then they will endorse it. And therefrom, you don't need to go to any court, you just go direct to any nearest deputy sheriff and have it enforced. Whereas in Namibia, it's a process. And also that one, you are looking for it. It's not guaranteed to say each and every labor inspector you are going to approach, they are going to enforce it. Some labor inspectors will tell you, I can't have it enforced because it's not provided for in the law. and therefore I'm a little bit reluctant. I don't know if I should enforce it or I can't enforce it. And as a result, it remains like that. No one is enforcing it for you. Your problem is not solved. The case is there now, outstanding for years and years, because nothing is bringing it to an end. As much as a decision is made, no one can take action on that decision of settling. You understand the challenge that is there. But in South Africa, you don't even need to have a case before the CCMA. You just need to enter into a settlement agreement, present it before the CCMA. They find signatures, endorse it, they give it back to you. You go have it enforced through the deputy sheriff. In Namibia, that's not the case. In Namibia also, you would find, besides, you cannot present a settlement agreement that you entered into before a case was lodged for you to have that settlement agreement be made a court order. There's no provision for that in Namibia. The only time the arbitrator will have powers to name it or call it award by agreement is when there's a dispute already before the office of the Labour Commissioner and an arbitrator has been assigned or appointed. That arbitrator who is appointed is the one who is going to now turn your terms of settlement into an award by agreement. Because why are we calling it an award? Because whatever decision the arbitrator is going to make, it's an award, except maybe for rulings where there are preliminary issues involved. But the decision the arbitrator makes at the end of every arbitration, it's an award. So if parties have entered into this settlement, it's an award by agreement. So parties have agreed to this and this and this, and we are making it an award. Therefore, take it to the Labour Court, go make it a court order, and then it can be enforced by labour inspectors and or deputy sheriff. So the system already differs a little bit from South Africa. However, to answer the question that is running through people's mind or troubling people, because most people are facing this challenge whereby they enter into a settlement agreement, the next thing they are told, we can't enforce it, or somebody is sitting on it for years because they are not sure on what to do. A settlement agreement is binding on both parties. The only challenge that comes is just the process. However, there are a lot of trainings that are being done now at the Office of the Labour Commissioner. Labour inspectors have been trained on this now. Most of them at least know to say they can proceed to have it enforced. However, it's arguable in law because the law on that aspect is not clear. It's just there. And as a result, you find anyone can interpret it the way they deem it fit on their clients. Even me, I would do the same thing. But anyway, in simple terms, yeah, a settlement agreement is binding on the parties and it's enforceable. It's a little bit of a cumbersome process to have it being enforced, but it is enforceable. Very practical. It has happened. Yes, there are also cases whereby it has not been enforced. They've refused to enforce it. It's unfortunate, but in simple terms, it is. So viewers, that was just a discussion for today. Very much brief, I think. But it's nice. It's a challenge that most companies face, because you find employees at one point would go like, no, I don't want to proceed anymore with the settlement agreement. Maybe because somebody would have told them, no, you make more money if you go for arbitration. Then you want to change your mind. Or the employer decides, no, we're not going to pay anymore what we expected to pay. We've realized actually we have a strong case. So you'd find once the signatures are there, both parties are bound, and provided a proper process has been followed, it's enforced. If it's done before a case is referred, once a case is referred at the Office of the Labour Commissioner, one uses it as a preliminary issue. If it is done after a case is already referred, it can be made an award by agreement, and then it follows the process that I just explained. So viewers, leave your comment. Let me know what your views are regarding this topic. Let me know what else you want me to discuss. And also comment, subscribe, tell a friend to tell a friend, share. Let's make this channel grow. It's to the benefit of a lot of people who may not have access to proper, I'm using the word proper, labor advice or employment advice. I'm so happy to say I've worked at the Labor Commissioner, I've worked at law firms that deal with labor matters. I'm proud to say I'm a specialist in labor matters and I know what I'm talking about. It's based on experience. And right now I own my own consultancy, which we specialize in consultancy and business as well. So this is just free advice for those. It's something that is simple. You know, I don't need to charge anybody for this. So let's make our channel big. Subscribe. Let's tell our friends so that we can grow it up. And thank you so much. Those ones who are already my viewers, thank you so much. My subscribers, thank you so much. The likes, let's increase them. And yeah, Merry Christmas and a prosperous 2023. Bye.